Good morning, everyone. Today is Wednesday, 10 a.m., about a daylight time. It's actually a little bit late, and I apologize for this. This was my problem that I could not connect earlier. Not to dive into the specifics, you probably don't want to know that, but regardless, we're back again. Today it's just me and Alicia. Alicia and I. Mark is busy with one of the very important files that he's working on. But we're here to answer your very best questions. And as we wait for people to pile in, Alicia, how are you doing?
Doing all right, Igor. Yeah, it's busy times in immigration. We have lots of clients who were able to get invitations to apply in the big
Mhm.
draws right before the end of the year last year. So, working through a number of those right now, trying to get applications filed under express entry. And yeah, a lot of clients who have fingers crossed hoping for another draw today. We'll see. I don't know about you, Igor, but this last week has been really problematic for trying to access IRCC portals of all
Mhm.
kinds.
Mhm.
There have been a lot of unscheduled and then a few scheduled outages as well. And so it's been difficult for people to try to access IRCC portals this week for sure. So hopefully they get that under control. But yeah, here we are. As always, Igor and I are both Canadian immigration lawyers, and this live Q&A is for you, for people to ask questions about immigration law. Even though we are lawyers, we cannot give immigration legal advice. We're giving immigration information. And so if you do need immigration legal advice, please go to our law firm. So Holthe Immigration Law, Holthe Immigration Law, and you can go and you can book a consult. Igor is sharing the screen. You can find a time that works for you with Mark or Igor or myself, and that's where we can actually go through your specific situation, get more details from you in order to give you targeted advice.
Mhm. Yeah. Alicia, we're still waiting for more people to pile in. I see we have around 30 viewers across different platforms. For those who are watching, just let us know where you tune in from. Let's get this live stream up and running. You know, the more comments you post, the more YouTube will recommend it to other people. And obviously, for those who are watching and not yet subscribed, believe me or not, this happens more often than you can expect. Make sure that you subscribe to this YouTube channel and hit the bell button so that you always get a notification when we go live. Alicia, you mentioned something very interesting. So we have quite a few express entry clients because of those large invitations. What is the main problem that you see with those clients when they come to us and say, "Hooray, I got an ITA, can you help me out?"
Mhm. I think right now, Igor, because people mostly have been in Canada for a long time. So I have a number of clients who have really been waiting for that CRS to come down. And maybe what you can do is flip over and take a look at the rounds of invitation and just see what's been happening, because we really have not had a large CRS draw that made the CRS score go all the way down to 511 until the very end of the year. And so what that means is a lot of people have been waiting for a very long time for that CRS score to dip all the way down to 511. And I've had issues with clients whose language tests were about to expire. So now we were hustling to try to make sure to get that application for the EAPR submitted and complete before the language tests expire, because if they expire, then the profile is no longer valid. You're going to get refused. So language tests are key for the principal applicant and for spouses as well. The other thing that I've been noticing is sometimes people don't retain us until after they get an ITA, and they may have done two, three, four, five, six, seven applications on their own in the past over the last 5 years. And immigration, understand, immigration is scrubbing everything. They are cross checking and cross referencing all your previous applications. So it is so important that you are diligent and you are very thorough with understanding what you've put in your previous applications. And if there are mistakes, or if you've claimed your work history differently, or if you didn't understand what the definition of common law spouse was, and you put something different in your previous applications, and now you're trying to include or trying to do something and you have a spouse, you need to get that correct. So take a look. Mark and I recorded a podcast on express entry and spouses. Hopefully that one's been released. I'm not sure actually if
Let's
it's
take a
if
look.
it's up there on our website. Yeah. So the
Mhm.
way you find our podcasts, the way you find our content is if you go to our website, we have the blog, we also have the YouTube channel, and then we have the podcasts. So if you take a look at the Canadian Immigration Podcast, then here we go. It's right here. So it has been released. That's the most recent podcast Mark and I have recorded because this has been an issue that I've seen cropping up again and again with respect to spouses. So sometimes people don't realize the definition under Canadian immigration law is if you've cohabited 12 months continuous in a conjugal relationship with somebody, then Canada views you as common law partners. And so immigration can say it's misrepresentation if you try to massage that definition and don't declare people as a spouse.
Yeah, and Alicia, I've had a client who was so diligent. Um, she she thought about it even before I could even mention that to her during the consult. She's like, I actually was so careful with us hitting the 1 year, and as soon as we hit 1 year, in our next taxes, we declared ourselves as common law, and then in our future applications, we also declared. And I'm like, I just want to hug you because like this is so rare that people actually pay attention to those minor details. And believe me or not, it's the minor, tiny things that make or break the application. It's not like, okay, can I can I demonstrate 3 years of work experience? You may be able to do that, but if your letter's missing one tiny thing, maybe there's no email in your reference letter, forget about it, right? So it's our job is not always just looking at the things from a 10,000-foot level, but actually going into details and spotting those tiny mistakes. And when we do that, then that's when the people realize, okay, it probably was a good idea not to just blindly believe, RCC when they say, oh, it's so easy, just submit an application. You actually need to go and start looking into details. And that being said, the biggest challenge I see right now with clients is when they come to us after the ITA. I just recently had a client, perfect scenario, young candidate, speaks perfect English, has qualifying work experience, just an ideal express entry candidate. There are some issues with the score calculation just because the system rounds up his score, but the other problem is that when he selected the knock code, he selected a different knock code just to fit into the category. And that's a bad, bad, bad decision, especially if you cannot justify that you actually perform the duties mentioned in that knock code. So the question then becomes, what do we do? Can we proceed with an EAPR? Should we not proceed with EAPR? And for this person, if he doesn't, then there is no second chance. And so
Yeah.
it's always a good idea to start thinking about your EAPR at this stage when you create a profile. And that is probably my best advice during today's live Q&A. Hopefully, we're gonna get some really good questions, and we'll share some other helpful insights. But for now, I see this is the biggest problem, and not many people expected an ITA at this low score, and I still cannot believe that we're saying 511 is a low score. But that's the world we live in. All right. On that note, let's pull up some comments. Let's give shout outs to our viewers. So we have Yasmin and we have Joe, who accidentally named me Mark and then he corrected his mistake. You're forgiven, Joe. Good morning to you. Okay, we have our faithful follower Spider Man from Beijing, and then we have the chapter after you, Raleigh, North Carolina. Uh, Ramsey says, Joe, it's Igor, not Mark. Um, we have Geraldine from Ghana, again, Spidey. We have Tenekia Silvera. I'm not sure if I pronounced that correctly, but good morning to you as well. in the Gothic society, greetings everyone. Um, Good morning to you. Watching from Fort McMurray, good. Good morning. And then I think we have the first question there from Ramsey. So good morning. First, I'd like to thank you for your time. You're very welcome. I have an AUR issued December 16th, but still no biometrics instructions letter. Should I contact RCC or I wait a bit? I'm an outlet candidate.
Yeah, and so Igor, I was just taking a look at the application processing times for various applications. Uh, it's hard to say, Ramsey, if you're express entry or if you're maybe a PNP, but it's not unusual. If you've just got acknowledgement of receipt December 16th, we're only at January, they may or may not request the biometrics instruction letter right away. Sometimes they do, sometimes it takes a little bit. At a month, I would not reach out and contact IRCC. I would wait a little bit if it were me, just because you're within normal processing standards. So if it is express entry, you're looking at an average processing standard of 6 months is their target. And sometimes that biometric instruction letter comes right away. Sometimes it takes a little bit, but the processing of your file should still be moving along. If you get past a 6-month mark, that's where I would reach out and contact IRCC. But if you just filed right away last month, then yeah, it's early still.
Yeah, and just keep in mind that 55% of all PR applications are in the backlog. So not that it is a norm, it's something that it's okay. It's not okay that 55% are in a backlog, but it takes time. And especially take a look at those rounds of invitations when they invite so many people and they need to process them. And it takes time, and they have very limited resources as well. All right, Alicia, I think we also have a super chat. Okay, so let's pull that one up. Hi, is this a myth that people can move to a different province or change occupations once they get permanent residence through express entry PNP? Would this be a problem when they re-enter Canada or apply for citizenship? Wow, wonderful question. I think um, it deserves another blog post on our website.
And Igor, I think actually Mark and I did do a whole episode
Mm,
on
mm-hmm.
settlement and what is your intention in terms of province and what you declare when you're doing an express entry or linked to a PNP, or even one of the PNP programs alone that are not express entry linked. But anytime you have received your permanent residence through a provincial nominee nomination, whether it's express entry linked or whether it's PR portal, which is the old paper based, basically you have had to prove to the province, whichever province it was and whatever category you applied under, that you have an intention to stay in that province. And that's why they nominated you, because they want you to stay. And you took a spot that they would have given to somebody else who would stay. So once you become a permanent resident, yes, you do have mobility rights under the charter. At the same time, you have an obligation to uphold that intention because you've literally signed documentation and attestations to the provincial government and to the federal government saying, this was my honest intention. And they can come back and say you've misrepresented if there's evidence that as soon as you get your PR, you hightail it and you're out of that province, you're changing your employers, you're pulling your kids out of school, you're going to a different province as soon as you get PR. And that definitely can come back to haunt you when you try to apply for a PR card extension, or if you go to apply for citizenship and you didn't stay at all in the province that nominated you. They're going to have serious questions about that. So it is a problem if you are not honoring your legitimate intention. At some point, if you have made an honest go of it and you've said, you know what, I'm working here, I'm living here, and you've tried for a year to make things work, maybe your housing situation has changed, maybe your employment situation has changed, maybe something in your life has changed or health, and really things need to change and you've made an honest go of it in that province, then sometimes there is a way that you can say, look, I did my best, things have changed in my life, and here's why I was moving to a different province. But they're going to check. They're going to ask questions.
Mm-hmm. All right, I've selected the next couple of questions. So let's take a look at this one. Any idea what's going on with Alberta Rural Renewal Stream? They only issued 10 nominations since 2026, and it doesn't show the current assessing applications received on or before the time like they used to do. Mm-hmm.
Yeah.
You're
Yeah.
not the only one feeling frustrated about AAP not showing the details of how they select people, but um,
So yeah, maybe Igor, you can pull up AAIP. We're in a little bit of a black box with AAIP. We usually are in a little bit of a black box with AAIP. They don't tell us. They don't tell the public. They don't like to reveal the parameters under which they're doing draws. There has not been an update in terms of public updates since November 18th when they talked about the fact that there were going to be rural renewal updates. They haven't done a lot in terms of telling us what's happening with processing. So it's for sure difficult for people who are pinning their hopes on an AAIP. This is why normally Igor and Mark and I recommend that if you have a federal express entry option, you also pursue that because there are no guarantees under AAIP. There are things that you can do to try to make sure, of course, if you have a worker EOI profile under AAIP, make sure that it is correct. I've seen a number of instances where AAIP is coming back and they are auditing the employer, they are checking business licenses, they are going through and calling people to make sure that they are eligible for the points that they've claimed. A big thing is if you go to the AAIP website, there's frequently asked questions or commonly asked questions specifically with respect to your highest level of education claimed in your worker EOI profile and also with respect to the regulated occupation certification. This is where I'm seeing a lot of issues with people who had tried to submit an AAIP application after notification of interest, or they actually got a nomination and Alberta's coming back and taking away the nomination because they've made errors in terms of how they initially claimed this. So be careful with AAIP. We're still waiting on updates from them in general.
yeah. And Alicia, this is something that we've also noticed in the past. Remember how earlier you would see AAP sharing the actual parameters for every single draw that they do? Like, okay, we're looking at candidates with 68 points, work experience in these major groups, work permit, like, I don't know, postgrad work permit, every other work permit would not be eligible. And right now it's just a lottery, right? It just the best advice we can give is create a profile if you're eligible. Make sure that whatever you declare in that profile is accurate, and then you're essentially just buying a lottery ticket. Whether you will win or not, like it's impossible to tell. Um, I know some people say, "Oh, PNPs are still the most predictable thing that we have in Canadian immigration." I'm like, it's actually vice versa. Like PNP is your backup plan right now, at least in terms of predictability. Maybe in terms of the competition, yes, it's better than Express Entry where you have over 100,000 people in the pool. But here, you have 60,000 people in a pool. So maybe it's not as beneficial compared to other programs, and that's why like um, we're so bullish on French, and we push our clients to study French, and we've been doing that for the last couple of years. Which
And maybe,
also leads me to another interesting link that I wanted to share with our viewers, and I will let you introduce that while I'm pulling this one up.
mhm. So IRCC just made another announcement. It's with respect to French and whether you can meet that Francophone cutoff. And so keep in mind that in order to be eligible for targeted draws under Express Entry in the category based, you have to meet regular program eligibility. You have to have CEC eligibility or FSW or FST, which is less likely. But all right, they've said, great, we have exceeded our Francophone immigration target for 2025. It was at 8.9%. This target keeps going up. So let me say that again. The Francophone target keeps going up. So they want to increase this to 12% in terms of how many Francophone PRs they are letting in. And so that means that they have actually opened up an additional 5,000 federal spaces for provinces and territories to designate French-speaking immigrants. And this is over and above the regular allocation to the provinces in terms of their nomination spots. So again, there's never been a better time to be Francophone, to learn French. Make sure you're getting your French levels up to an NCLC level 7 across the board, and you have to have that TEF or the TCF exam to back up the fact that you are Francophone speaking. So, this is another initiative. It's yet another instance of the fact that if you are really serious about becoming a permanent resident in Canada, and you otherwise are not getting the points that you need, your best bet is probably to learn French.
Yeah, and Alicia, it's also interesting. Like we have like we go through different stages, right? So at one point of time, there were a ton of foreign nationals coming from India, Pakistan. Now we have a ton of applicants coming from Haiti, Cameroon, Vietnam, um, francophone like countries. What's next? Who do we invite next? Do we invite more people from China? Do we invite more people from Mexico? I'm just like it just looks to me like we're going through different seasons. Season one, Canadian immigration, you know, and then we we invite pretty much people from one geographic region. Season two, a different geographic region. Do you
And it,
envision that the season three will be someone else?
well, and this is the whole reason we had Express Entry in the first place. The whole reason we had Express Entry in the first place is not to pick winners and losers. It is literally to say, let's even the playing field and let's have human capital priorities. And we'll say, okay, we know that we value age, right? We want people who are younger so that they can be in their prime working years, they can contribute, maybe they can have kids because Canada has such a low birth rate, and they're less likely, hopefully, to go on medical leave or to have medical issues that require healthcare. So we know one of the kind of human capital points that we're looking at is age. The other is education. So Mark Carney was just saying, Canada's probably the highest educated population in the world, right? So
Mm-hmm.
we have people who have a very high level of education. And generally, if you have a younger age, high education, and fantastic language points, and we know right now you have to basically have perfect English in order to have a competitive CRS. But English or French as language is really going to help you be employable. That's one of the biggest factors in terms of whether people can find jobs in Canada is how strong your language is. So we've got age, we've got education, we've got language. Those are really strong human capital aspects. And then we talk about family members and we talk about other things like do you have the ability to be established in Canada? And so those Express Entry core elements were supposed to set an even playing field so that people could understand, all right, these are my CRS scores. It is what it is. But what's happened is we've really skewed things in favor of French. Right? We took away the points for job offers. So that had been skewing things in terms of people who had LMIAs or who had been working under closed work permits for at least a year. That had given a leg up to older individuals who had high skilled work experience in a particular closed work permit. When we took that away and instead we bumped up the French, that has definitely skewed the playing field. And so that's the flavor right now. That's what immigration is prioritizing, but it is taking away from the general human capital.
Mm-hmm. Okay. And Alicia, as you mentioned, job offers, I think there was a really cool question about a job offer. Let me see, one moment. I'm just trying to find it. Give me a second. Um, how do I? Job. Okay, I think I have it. So, question for job offer in Express Entry profile. Has person A been working for full time for the employer on their current work permit for at least 1 year? Does it apply if I had a 1 year post-grad work permit before getting the closed work permit? And so what I think Kevin is asking here is, can he answer the question about the job offer as yes? Maybe right now is less important compared to how it was in the past, but it's still an important question.
Hmm. So this is where, yes, they've taken away job offer points under your CRS score, but depending on whether you need the federal skilled worker eligibility criteria or not, that is where job offer actually still matters. So you still get points under the 67 selection pass mark for arranged employment. Take a look at my article. I've updated it. It is on our website under the blog on arranged employment and can I claim job offer points, because I go into this in detail. Sometimes it is worthwhile sorting this out and making sure that you're properly claiming these job offer points if you need it to get your selection 67-point pass mark, because that arranged employment can make or break whether you hit the pass mark. And also it makes a difference in whether you have to prove settlement funds or not. If you have arranged employment, you may not need to prove settlement funds. But you have to be correct, because a PGWP is never going to give you arranged employment. So if you are on an open work permit, it is not going to give you arranged employment. You cannot get the 67-point pass mark, the 10 or the 5 points for arranged employment to bump up your score if it's a postgrad work permit, because an open work permit is never going to qualify for arranged employment. It has to be LMIA based, or it has to be a closed employer specific work permit. That said, with some clients, I do recommend that they answer these questions if they are also trying to do a PNP program. So a lot of the PNP programs are employer based, or they require a job offer. The technical term for arranged employment under federal express entry is a little bit different than a job offer under the PNP programs, depending on which PNP program you're looking at. So to circle back to this question, it depends on what your employment has been like with this employer, but you never want to say that you're on a closed work permit if you're on an open PGWP work permit. So you can say, yes, I have a job offer from my employer, but there's another question that says, do you have an LMIA? Or there's another question that talks about effectively, were you working for that employer on this work permit? And basically they're saying, were you working on a named employer work permit? And you're not on an open PGWP. So take a look at those questions carefully. Take a look at my article. Um, and the only reason that you would answer these questions, yes, is if you are also trying to do a PNP nomination where it's linked to your express entry profile and you want the province to be able to see, yes, I do have a job offer, not for claiming points at all under express entry, but because you're trying to meet program criteria under the PNP.
Yeah, and I remember there's another thing with the job offer, is that your job offer needs to say that your employer is willing to keep you employed for at least 1 year after you get permanent residence. And I've seen a ton of refusals just
Mhm.
because the job offer was missing that sentence. So be very careful with this. And Alicia, I think we have another question that just landed in the chat. I'm on a Francophone mobility work permit since December 2025. On Express Entry profile, should I say yes on the job offer? Well, Francophone mobility work permit is an employer-specific work permit, so technically, yes. But have you worked for that employer for 1 year? No. So there you answer. We have a super chat from Juan. Juan. I'm not sure. Sorry. I'm doing my best, trying to figure out how to pronounce those YouTube handles. But do TEF and TCF results for French must be obtained, like, do they need to be obtained in Canada, or can I pass the language test in any other country? Well,
Mhm.
easy, right?
Yep, yep. So any country. So as long as you are taking the standardized test, as long as you are taking a TEF or a TCF exam, you can take it anywhere. Same thing with if you're looking at English tests, you're taking the IELTS General or the CELPIP General or the Pearson test for English, and you can take them anywhere as long as it's a proper testing facility for that organization. They're going to send you the results, and then once you have those results, that is what you need before you can create your profile. So just make sure. I've talked with people over the years who said, oh, I just created a placeholder account and I just
Mm,
made up numbers in order to create an express entry profile. Please don't do that. Do not do that. Make sure that you wait for your language tests and your education credential assessments in order to create your profile.
Alicia, I cannot help but pull up this comment. I love you too, Zeus. You're awesome. And Shirley says, thank you both. Well, thank you guys for joining and watching this live Q&A and listening to our rants and me complaining about immigration, because I tend to be a little more pessimistic than an average human being, but that's just my nature. All right, let's move on. Okay, so we have a question from Joe, um, our faithful follower. Okay, so does moving to to in does moving in Saskatchewan to
Saskatchewan.
live okay, does moving to Saskatchewan to live but still working for Alberta-based company, working there for 4 years, can work remotely, has any implications if I'm picked by AAP? If a wife got a JAL, I think it's the employer attestation letter. She can apply for SINP. Um, okay, we probably need to
The
know a little more context and
Saskatchewan
details.
Immigration Nominee Program.
Yeah, but
Joe,
with
this is
Alberta,
complex.
can you be
Yeah.
selected if you live in Saskatchewan but you work for an Alberta-based employer?
Yeah, and so it gets even more complicated with your intention if your wife is also trying to apply for the Saskatchewan
Mm,
Immigrant Nominee Program,
mm,
because the provinces share information. And so they will know that, you are trying to hedge your bets with AAIP, but then your spouse is trying to do a Saskatchewan Immigrant Nominee Program. So they are going to have questions about what is your intent? Where is your family going to settle? Are they going to be in Alberta? Are they going to be in Saskatchewan? um, I think you essentially need to choose
yeah,
between you and your spouse and just say, look, we're going to put our eggs in the basket of being in one province or the other, but to try to have a foot in each province and to hedge your bets. Um, Eventually, they're going to say, this doesn't make sense in terms of your intention.
yeah. And Alicia, I cannot say I like how Manitoba does it, but they are very serious on your intention to reside in Manitoba. If you ever or your relative ever worked in any other province than Manitoba, they immediately cut 100 points out of you, and there is no shot for you getting a PNP through Manitoba. That's how serious provinces are trying to retain those people. And so, if indeed you try to shop around, and maybe try here, maybe have a backup plan in another province, that will never play nice. Um, okay. All right. Next question: if someone comes to Canada as a visitor and then gets permanent residence after 2 years of stay in here and also stays for another 2 years as a permanent resident without leaving and also files taxes for 3 years, will they be eligible for citizenship? Uh, to me, it seems more like a very case specific question, but in general, so if you want to consult whether you would be eligible or not, we cannot tell you because we don't know all the circumstances and details of your situation. But in general, you can include time you spent in temporary status in Canada within the 5 period before you submit an application towards the physical presence calculation. And that time that you spend in temporary status, each day counts as half day. So you can accumulate a
Up to a
maximum of
maximum of
one
a
year,
year.
yeah, to a physical presence. So that's how it works. Whether this will apply to you, whether it will work out for you, it's just too risky for us to answer it with certainty in this live Q&A without knowing the details. So we absolutely would recommend that you book a consult. So there's this triangle sound, and to do that, you would want to go to our website where you can find Alicia's blog and all of the other helpful resources. And then on the main page, there's a beautiful, big, just like Donald Trump, beautiful, big button. You click on it, and then you choose with whom you would want to speak and for how long. And we would be happy to connect with you. Okay. Um, oh my goodness, Alicia. You're going to love this
And
one.
one thing before one thing before we switch away from that. Um, There's differences for permanent residency and making sure you're meeting your PR eligibility and renewal. So permanent residency, keep in mind you have a residency obligation, and within every 5-year period, so the start date is your confirmation of permanent residence, your COPR. Whatever your COPR is, then you look forward in time and you see within a 5-year period, can you show that you have 2 years of physical presence in Canada as a permanent resident? And this is where Igor is talking about days of residency. Now, when you look at a permanent residency, if you've hit 3 years, 1,095 days, then you may or may not be eligible for citizenship. So keep in mind there's 2 different tests. Maintaining your permanent residency is really, really important, because if you lose your PR, you're not eligible for citizenship. But if you maintain your PR 2 years within every 5 years, and then you also have 3 years of PR within that 5-year period, then you might be eligible for citizenship. There are citizenship bars. So yes, there are other factors that you'd have to take a look at in terms of eligibility for citizenship.
Yep, exactly. Alicia, we have one super chat from Darshila Shava. I'm not sure if that's one name or it's the first name, last name. Regardless, here's the question. Okay, I have a CLB 7 in TEF, which basically means NCLC 7 for French, right? So my work experience will be completed in April. Again, I'm not sure about the exact number of years, but the person will cross the threshold in April. My IELTS score will expire in September, so 5 months after that. So does my IELTS need to be valid after receiving an ITA, and the CRS score will be 470. So a couple of things that we would want to talk about here, right? Okay, you probably start, right?
Okay, so yes, you can have a primary and a secondary language. So if you have an IELTS and a TEF, you can choose which one you want to designate as your primary language. Hopefully you're getting your IELTS scores. Um, I guess I don't know. So Darshila, we don't know if your work experience is in Canada or outside of Canada. So it might be foreign work experience, it might be Canadian work experience. If you are looking at eligibility under federal skilled worker, you have to hit that NCLC 7 across the board in French, or English 7s across the board CLB. One of those has to be there to make you eligible for federal skilled worker if you're looking at foreign work experience and you don't have your 1-year Canadian. If you do have your 1-year Canadian work experience, then you need to have an eligible profile, right? So either you've got minimum eligibility under CEC or minimum eligibility under FSW, and then you can designate which language you want as your primary. It can make a difference in your points. So run your points calculation with both. Check if you're going to get a higher score with your English as primary language or French with primary language. Sometimes it does make a difference. The next thing is, whenever you have a profile, you must have a valid language test result. So in order to keep that profile active, your language test cannot be older than 2 years. If you get an ITA, what happens is your profile is locked and you can't change it, but your exam can still expire. So before you submit your EAPR, you must still have a valid language test for all the points that you're claiming and your minimum eligibility. Do you want to add anything to that, Igor?
Um, yeah. So, sorry. While you were answering, as always, I'm just scanning through the chat, trying to sort out the questions. But I'm not sure if you mentioned this, but the IELTS needs to be valid not only after receiving an ITA, but it needs to be valid when you submit your EAPR.
Yeah.
Because if you receive an ITA and your IELTS expires the next day, by the time you submit an EAPR, you will submit an expired document. Your application will be returned, and with all of the consequences, right? It's not even deemed like the returned application is deemed not to be submitted, right? So you don't even technically enjoy maintain status at that time, right? Like, so you fall out of status as soon as the work permit expires. So it's super important that you pay attention to this. And again, it's the date of the test score, the test results, not the date when you sit for the test, right? So maybe that will also make or break it for you. Okay. Alicia, we have one more super chat, but it seems to me that we would send this person to speak with us at a consult, because it just requires us to do a little more research before we can answer this with any degree of certainty. So I'm a certified pest control technician. My occupation is listed in eligible occupations list of certificate of qualification.
Certificates of qualification.
There is no authority in BC to provide the certificate of qualification for this trade. Do I claim it in my expert entry? Do I, should I, can I, may I? All of that prompts me to press this button. And you would want to go to our website, and our website is right in here. It's holthelaw.com, and then you click Speak to a Lawyer, and you choose with whom you would want to speak. And as much as we would want to answer this question, we just don't feel it's correct doing it here without knowing the details.
Yeah, I would say one thing you can do, maybe Igor, is you can include the link for the A11.2 completeness check, because there is a whole section on certificates of qualification. So if you take a look at step 1 and step 2 under the comprehensive ranking score, and you can see that the pest controllers are on there, but there's a whole step process under step 1 and step 2 of whether you can assess this in terms of, are there points for certificate of qualification or not. So we'll give you that resource. But yes, we can't provide specific advice.
No. And if you want to try to find it, just expert entry assessing electronic application on section A11.2. Try searching in Google for this exact source. IRCC is terrible because they stopped indexing their pages on Google, which I have no explanation why, but that's what we have. All right. Zeus is asking an amazing question, okay? Please explain, what does on balance of probabilities means? Seen this in the officer notes in the past. So it takes us all the way back to year 1 of our law schools, and the standards of proof, beyond reasonable doubt, on balance of probabilities, all of that. Alicia, maybe you can explain how this works.
No way, Igor, you just did this. You get to explain this.
All right. So Zeus, there are different standards of proof, right? In criminal law, to convict someone, the guilt must be proven beyond a reasonable doubt. So it's not like 100%, but it's close to 100%. So look at this at a scale, right? And so would a regular, reasonable person find it convincing that the act took place and the person wanted to commit a crime? It has to be, it has to reach that like end of this threshold. You know, it has to be almost certain. Like you cannot say I know exactly how this happened, but you have to say I am convinced that this indeed happened. Okay, it's not like I think it might have happened, it could not have happened, maybe someone else did it. You have to be pretty much confident to a degree of like 100% certainty, but it does not need to be 100%. With immigration, on balance of probabilities means that the officer assesses, is it likely that this happened or it's not likely? Do I have enough evidence to suggest that this might have happened? If I have enough evidence, then on balance of probabilities, it's more probable that this happened rather than not. Okay, and so different areas of law have different standards of proof, and so in immigration we use balance of probabilities, right? So again, the
Unless we're looking
officer.
at federal court. Unless we're looking at federal court.
Yes, yeah, and so this is where we have federal court come in and look at the decisions of an officer, saying was it reasonable for the officer to conclude something or not? Did the officer explain, and there are reasons why they believe that on balance of probability something happened or something did not happen, right? And so it's just one of the standards of proof. It's a lot lower than in criminal law, but it's still like the officer cannot just say, I don't believe you. There's no need for me to explain things. The officer must explain why they think like in one way or another, and they need to show that they had enough information and evidence to think that it was more likely that it happened rather than not. Sorry, I'm just trying to put it in very simple terms. Again, you can find like books on this whole topic, right? And this is what we study in law school, pretty much. Okay. Alicia, do you want to add anything here?
So anything that you're claiming in an application as the principal applicant, you have to prove, right? You have the onus of proof. And so this is where the officer is going to only weigh and assess what you've provided. And if you fail to provide them something, there is zero obligation for immigration to reach out and ask you for additional documents.
Mm-hmm.
Zero.
Yeah.
So a lot of times people think, oh, well, I'll just provide them the basics, and if they need more, I can give it. Mm-mm. They are only going to assess exactly what you provided because you have the onus of proof. You're the one who has to prove your case for whatever you're trying to claim. And they will look at, on a balance of probabilities, have you established all the points that you're trying to claim? This especially comes in with respect to work, right? So when you're looking at assessing your previous work history or your Canadian work history, can you show on a balance of probabilities that, yes, these are the knocks that I've claimed is correct, it's the lead statement, it's the main duties, I have the hours that I've claimed, did I provide proof of settlement funds? All these things the officer is going to assess. But it is your obligation to provide sufficient evidence.
Mm-hmm. Mm-hmm. Yeah. And Alicia, I can help but mention this judicial review file that I'm working on, and it's for the client who claimed work experience as a carpenter. An RCC officer came back. Like, I have to be honest, they are on a treasure hunt after this guy. They try to accuse him of not being in Canada during the period when he was in Canada. Like, it's insane what's going on with this file. But long story short, one of the key issues that we're dealing with is that the officer did not believe that the person actually could work as a carpenter. He said, "You know what? You were like a trades helper. Like, you were bringing materials, maybe hammering a nail, once in a while. But carpenter, really? How could you be a carpenter if you did not work as a carpenter before, or you did not even work as a construction helper?" And so this is where this balance of probabilities comes up, right? And this is where the applicant must not only provide a reference letter sometimes, right? Like, even though the RCC only asks you for the reference letter, it's really up to you what you provide to an officer. And the more convincing your evidence, the better. So when people say, oh, I can provide an officer with 200 pages, should I do it? In some cases, yes. In some cases, yes, believe me or not, but not every time. Um, but for this particular person, when he received the PFL, we provided a ton of documents explaining how he had prior exposure to woodworks. He was working with one of his family members. He had um, a woodworks class in his high school, so he knows how to hold a hammer. He was on a probation period. Somebody was teaching him, but he was doing the duties of that of a carpenter. And so if sufficient evidence is provided initially with the application, it's always better than rather than hoping that an officer would be knowledgeable enough about the concept of procedural fairness, and would send you a letter. Sometimes they just don't. They just refuse your application, and good luck trying to challenge it, saying officer breached the procedural fairness and he should have issued the PFL to me. Sometimes you just don't have that privilege. Um, Privilege, maybe it's the correct word. If there's a duty of the officer to issue the PFL, then they must do it. It's not a privilege; it's a right to know the case to meet. But sometimes it just doesn't happen. So that's why I'm saying it's a privilege. So absolutely, Zeus. We had like 10 minutes talking about this issue, but it's super important, and it's very important um, that you understand how it all works. And thanks a lot. Very well explained. Alicia, it looks like there might have been a draw.
Was there a
What?
draw?
What? Somebody got an invitation today. Huh.
All right, everybody search, everybody refresh your browsers, see if there was a round
What?
of invitations.
Did I misunderstand this comment? CRS draws 509. I got an invitation today. Yay, yay, yay. Interesting. Maybe I'm missing something? No, I'm not. No, I'm not. Oh my goodness. It just happened, like right right now. Let me pull up a different browser, and that's Express Entry. Uh,
Yeah, they did a CEC
found
6,509.
crazy. Why my Safari does not show it here?
I, I had to go incognito, Igor, because otherwise it kept
Of
pulling my old
course.
browser cache. But
All
yeah,
right.
if you refresh and you go incognito, then you can see there was just a brand new draw today. 6,000
Yes.
invitations to apply under Canadian Experience class. The cutoff was 509. The tie-breaking rule was October 29th, 2025. So here we go.
Yay. Congratulations. Congratulations to you. Think less, live more. What a wonderful YouTube handle. Um, but with Express Entry, you probably want to think more and and blindly believe RCC less. Very important in current realities. Yes, CEC 509, 392. Ooh, congratulations. 6,000 people. This is awesome. Amazing.
Yeah.
Uh, I'm so glad it's not a Francophone draw. Just so many people deserve to have an ITA. Like, you have to be brilliant to have this score. Like, I don't know. Like, you have to be young, you have to speak different languages at a very good level, you have to have foreign Canadian work experience, master's degree. Like, how do you accomplish all of this um, before you turn 30? It's crazy. But congratulations to those who received an ITA. You guys deserve it. All right, we have quite a few questions uh, left in our chat that were highlighted, but I'm not sure how do we manage all of this. Okay. Um, okay, I think we answered something similar. So I have received an ITA in December and completed my 1560 hours of work this week. I wanted to get your insight if should I choose to reject the ITA and submit a profile as my scores would be 540 to be safe. Well, Rahul, we have good news for you. That just happened like 10 minutes ago. You should have a new ITA right now.
Well, he said he received his ITA in December, so if he hasn't rejected it, he's waiting and trying to figure out what to do.
Yeah. Oh my goodness. Like, you have 60 days to submit your EAPR from the time of an ITA. If you received it at the early December, then um, you almost have no time to submit EAPR. Um, but Alicia, when it so happens that the system rounds up the score and gives you points for 1 year before you hit 1 year, what do we typically recommend people do?
Book a consult because we need to know more details, Rahul. But um, there are circumstances. So it depends on when your work permit expires. It depends on did you properly claim your work experience? Are those points actually what you think they are? And is it only an issue of rounding up or rounding down? Because I've seen all sorts of things. But if it's only an issue of you're short a few days, then depending on how risk averse you are, the choice is do you keep that ITA from December and do you make sure, like if you're only short a week or something like that, by the time you have to submit this in February, whatever date it is, I'm not sure which round you had in December, but whatever date you have to submit in February, will you have accumulated your extra week or whatever it is to make sure that you hit your full 1 year? If you needed to hit your CEC eligibility and you did not otherwise have federal skilled worker eligibility, that is very risky because now it's a different ballgame. So when did you create your EE profile and what did you say on your questionnaire? Because on the questionnaire, back a few months ago, whenever you created your profile, if you said you already had 1 year Canadian work experience and that was not correct, game over. I would say, no,
Mhm.
you should not proceed because it's not accurate that you would have been eligible to be in the pool when you created your profile.
Alicia,
So
and
we need to know more.
sorry for interrupting, but this is exactly the answer to the same question in here. Can I can I even create a profile at 11 months of work experience? Well, you don't have 1 year, so you can't.
Unless you qualify under FSW,
Yeah.
right? So if you qualified under FSW, you were hitting the section selection pass mark of 67 points, then you could, and then just wait for you to hit your also Canadian 1 year, and then you should be eligible under both categories. But what I'm saying is, if you do not have federal skilled worker eligibility and you're only looking at CEC, it's misrepresentation. It is not accurate at 11 months if you are only claiming, if you only have Canadian work experience, you shouldn't create a profile at 11 months because you can't truthfully answer the question on the questionnaire, yes, I have 1 year of Canadian work experience when you're creating your profile.
Mm-hmm. Mm-hmm. Okay. Um, all right. I think we have quite a couple of questions only left, and we'll be wrapping things up, and then shift over to our team meeting. So, um, let's see. I think there is another question from Rahul. I have applied for a TRV on December 1st from inland Canada and waiting for a decision. I need to travel out of country. What option do I have in trying to reach out to RCC as the timeline shows only 17 days? Well, uh, my biggest worry is with the terminology that you use in this question. So there's a big difference between a TRV and a visitor record. And you can apply for a TRV from inside Canada, but a TRV and the fact of submitting an application for a TRV does not give you maintain status. It's just an application to receive a sticker in your passport that allows you to travel to the border and speak to an officer. It's just like your entrance ticket, right? Whether they will admit you or not depends on an officer at the border. Visitor record is the document that gives you status in Canada. And so there are two different applications. You can apply for a visitor record and a TRV from inside Canada. You can. But if you if you relied on that status and you needed to maintain your status in Canada, but you applied for a TRV, then maybe there's bad news for you. So we need to know a little more details. But typically, Alicia, so if someone submits an application and waits for a decision, let's say on a visitor record, and leaves the country, that visitor record is invalidated the moment when you leave the country. That application will no longer be processed. You can only receive that visitor record while you're inside Canada. You cannot use visitor record to come into Canada unless you have that sticker in your passport. So there are a whole sort of questions and issues.
And also because Rahul is just the person that was asking about the ITA in December and trying to hit their 1 year mark. And Rahul, we'd need to know a whole bunch more
Mm-hmm,
information because
mm-hmm.
hopefully you also have a valid work permit, but you need to be super careful because you can only have implied or maintained status to continue to work if you stay inside the country. So unless you also have a valid work permit, it is extremely risky to be leaving the country. So
Mm-hmm.
we we need to talk with you for sure.
Yeah, and that triangle sound is the signal that you would want to go to our website and book a call. Um, you can find the link to our website in the description under this video as well. It just makes it easier for you. And it's right here on the scrolling ticker at the bottom of the screen. Okay. What did just happen? I wanted to select one question and then somehow it pulled up a totally different one. But okay, let's see. Okay, this one from Emmanuel is a good question. Are credit cards and loans deducted from your proof of funds? Short answer is yes, but there is a mechanism how they do it, right? It's not like if you have mortgage for $350,000 and you only have 70,000 in your bank account that you cannot immigrate to Canada until you pay off your mortgage. There are some rules to it. Alicia, you want to go into detail?
Yeah, so take a look at the settlement fund section under Express Entry. And basically, you need to show that over and above your debts and liabilities, probably on a monthly averaging basis, you can show those settlement funds amount that are accessible. It has to be liquid funds. So they don't count, like if you have a mortgage on real property, you have a house somewhere in the world, they don't count that as settlement funds because that's not necessarily liquid assets. It's not something that you might be able to sell depending on where you are. But they do look at your debt. So you will want to show that in your name, under your bank accounts or your savings accounts or your financial investments that you can liquidate, that you can access, you have that settlement fund requirement for your family size. So you plus spouse plus kids. You also need to show your debt. So if you have credit cards and you've got student loans, for example, you also want to show how much do you have in those and how are you servicing that debt? How are you paying off that debt on a monthly basis? Specifically for my American clients, this can get pretty complex because you're going to want to have calculations to show which accounts and how you're paying off your loans and your debts on what kind of basis. If you can show for sure your settlement fund amount over and above your credit card and your loan debt, that is what you'd like. That would be ideal. But sometimes it is possible to show here's how you are servicing monthly debt.
Yeah. And Alicia, like the whole concept of proof of funds, why would they want to see how much money you have? Because they want to make sure that when they let you in, you can economically establish yourself in Canada. And that's why, like, the
Yeah.
more family members you bring, the more money you need to sustain yourself in Canada while you're trying to find a job, while you're trying to rent a place. And so they use this low income cutoff score, they have their formula, and they basically calculate how much money they envision would be necessary to sustain yourself for the first 6 months. And so, um, more or less, right? And so, our approach is always to look at your debts. How much does it take to service the debt for 1 month, and then we multiply it by 6, and then we show for the next 6 months after I land in Canada, I have sufficient funds to sustain myself, so I will be above the threshold, and I will also have enough money on top of that to service my debts.
Right.
Maybe you will sell your house and you will no longer have mortgage when you immigrate. Well, that is what if you sell the house. Sometimes you cannot sell it right away, right? So we always try to explain to an officer, you have nothing to worry about. I will be financially sustainable in Canada. I can sustain myself and my family regardless. The more you show, the better, and the more accurate and precise you are with your debts and loans, the better. Okay, that's probably how I would answer this as well.
And the other thing is, it is possible to get a gift deed, right, from
Mm-hmm.
family. It's got to be family. So make sure that if you are asking for money from family in order to settle, usually it's your parents or your spouse's parents. And they are going to make sure to do a declaration. So a notarized document saying, yes, this is a gift deed. It's not a loan. There's no repayment. There's no interest due. They're literally giving you a gift so that your family can settle in Canada. It has to be of their free will, and you have to show where that money is coming from. So it's coming from your parents' account directly to your account, and those funds are settlement funds that you can use towards calculating your proof of funds. But you know, sometimes you don't have family who's willing to do that, and you might have to show your own settlement funds.
All right. Let's see. Uh, the last four questions, okay, and then we're gonna tune off. So, if outland spousal sponsorship takes 2 years, no, inland takes 2 years, and outland takes 1 year, what's the purpose of applying for inland?
And also because of the open work permits. So
Mm-hmm.
I actually just wrote an article about that not too long ago on our website. So if you go to our blog and you take a look at open spousal work permits and spousal sponsorships, there's more detail there. So be careful because there are some nuances in terms of who's eligible for that open spousal work permit and when you're eligible for it. Because right now we know that the processing times for an open work permit are huge, right? It's 220 days for a change of conditions or a work permit application. So practically, it might not be useful for an open work permit applicant just because how long the processing times are. But yes, if you are looking at different spousal options, there are benefits, there are differences between an inside Canada versus an outside Canada. Keep in mind that if you are doing a family inside Canada spouse or common law partner class, there is no right of appeal. And so if there's any question about the bona fides of your relationship, you should be doing a family class outside Canada application because that's the only circumstance where you have a right of appeal. So there are other factors to consider, not just the processing timelines and not just the work permit eligibility.
Yeah, but in general, um, the benefits of inland spousal sponsorship applications, they fade right now compared to outland, because again, processing times, work permit eligibility is pretty much identical. Outland gives you right of appeal, and for those people who wonder what is the difference between appeal and federal court, the difference is huge, right? First, the process is a lot more straightforward with an appeal rather than in federal court. Timing is a lot faster with an appeal rather than federal court. And then in appeal, you can provide other evidence to, like, introduce new evidence to justify that you are in a bona fide relationship. In federal court, the court only reviews whether the officer was reasonable in reaching the conclusion that they've reached. You cannot introduce new stuff. You basically go back to court and say, this is what was before the officer. The officer was not reasonable in refusing this application because of this and this and this, and you have to prove it. In appeal, you basically like the board reviews your file pretty much from scratch, and they make their own assessment.
Right. Yeah, you have a right to appeal. So
Yeah.
I agree with you, Fabs. There's practically almost no benefit in an inside Canada application right now because a lot of people don't understand that you can file a family class outside Canada application from inside Canada as long as you have valid status. You have to maintain your temporary residence, you have to maintain your dual intent. But if you file an outside Canada family class application, you then have the right of appeal to the Immigration Appeal Division if for some reason they think it's not a bona fide relationship. You have the faster processing times. You have the ability to go and come back into Canada if you have a visa. And you have the ability to apply for the open work permit if you meet eligibility criteria. So right now, family class outside Canada applications, so family class, even if you're physically present inside Canada, can still be filed. So I also have another article on our website, the differences between family class outside Canada and spouse or common law partner Canada applications. Take a look at that. But I agree with you, Igor. I agree with you, Fabs. There's kind of a winner right now in most circumstances.
Yeah, I think if RCC would remove any reference to outside and inside Canada application, it would remove a lot of confusion for the applicants. Because if they would just keep SCLP FC1, which is the coding for the application class, people would just refer to those by the codes rather than, oh, I'm inside Canada but I cannot file an outside Canada application. You actually can, and if you actually start working on your application and the first thing that you will be doing, you will be downloading the document checklist. It asks you what situation best describes your and they have three options. I'm in Canada and I'm applying for inside Canada class. I'm outside of Canada and applying family class. And I'm inside Canada and I'm also applying for family class. So three options. The last two will give you option to choose between family class from inside or outside Canada. So many people just miss it, Alicia. And another thing, which is kind of frustrating, I'll have to be honest, when you prepare the application in the RSCC portal, you generate the application and you select what application you want to submit, and then I've had several occasions when people would come to me and they ask the very same question at the consult, and we go into their application, and I'm like, guys, I'm so sorry, but whatever number of hours you spend filling this out, you'll just have to go and recreate the whole thing from scratch just because you selected the wrong application type. And you cannot just go and switch the application type with a toggle. No, you just have to create a new one from scratch, and it's just a huge waste of time. All right. Next question, Echo M9 is asking, regarding the RSSC reviewing past applications, should we worry about information entered and corrected in drafts or in drafts deleted before official submission? So what I'm thinking is happening here is Echo is asking, like, when I fill out my EAPR, but I don't hit the submit button, and then I go back and re-edit the information, is that okay? Or they somehow will go and see, like, what did I type before I hit the submit button?
Yeah, and it depends what you mean by drafts. So normally what I say is anything that you've actually submitted. So an express entry profile that you actually submitted, they see everything in there because you
Mm-hmm.
actually submitted that express entry profile. If you have a draft application that was never actually submitted, it never has a profile number, I would not worry about that because it was not submitted. It was just you were working on it.
Mm-hmm.
Um, but it is reasonable for IRCC to go back and cross-check study permits, visitor visa applications, anything you actually submitted that has a file number.
Yeah, because it's only when you submit an application, you sign it, and you put a check mark saying, I attest that whatever is here is true, accurate, and complete. And if it was so simple, that IRCC could go in and see the documents that were uploaded but not submitted, and Alicia, you know what I'm talking about here, that would save a lot of people from trouble, because when RCC asks you for additional documents, they say, oh, just upload them in your RCC secure account and send them to us. People upload it, upload the documents and the checklist. It lights up in green saying upload it. And then they're like, okay, I'm done. It shows up in green. No, until you actually click it through all the way to the end of the tunnel, and you hit the submit button until you no longer see submit button, it's not submitted to RCC, they will not see it, and they will refuse an application saying, we have not received anything from you, even though you uploaded stuff, but you did not submit it, because it says uploaded, not submitted. And many people miss that. So
Yeah.
I probably would not worry too much about drafts that were never sent to RCC.
Yeah.
This one is a great question. If you are on a visitor record, can you apply for Francophone mobility work permit from inside Canada, or you need to do it from another country? I'm
So,
trying to pull this one up as you're answering.
yeah, yeah. So you can go to Francophone Mobility work permit application pages. Usually, the normal rule is you're not allowed to apply from inside Canada on visitor status to be switched over to a work permit. That is normally the rule. However, they say there are exceptions to the rule in some sort of circumstances. So the way that a Mobilité Francophone work permit functions is your employer has to do the employer portal offer. So they have to submit that through the employer portal. They get an A number and an O number, and then you would use those on your work permit application in order to come back in and be issued a work permit is normally how this functions. Um, I know that people have been able to switch from visitor status to Mobilité Francophone in the past, but it really depends on your situation and your visa requirements and past policy, because most of the time now they're saying that you're not allowed to switch status from visitor to worker from inside the country.
And Alicia, it also creates another ethical question and potential concern. How did you get to Canada, and why did you get to Canada, and when? So
Right.
if you had a work permit that expired just a couple of days or weeks ago, and you are in the restoration period, and maybe um, you can apply to restore to a status of a worker. Maybe that would work. Um, If you came as a tourist and you said, "Oh, I'm just coming to see Niagara Falls," and then all of a sudden you have the employer who's willing to support you for the Francophone mobility work permit, the officer can reasonably ask the question: what was the actual purpose of your visit to Canada? Job
Hmm.
job searching, working without authorization? Maybe you did. Who knows, right? So all of those questions, they start popping up, and you have to be prepared answering this. So um,
Yeah.
just a couple of minutes ago, I've been sharing the screen, and you've seen the list of exceptions when you can apply for the work permit. So that's perhaps the most direct answer to your question, but there are caveats, as always. And I will pull this one up. Well, it depends, okay? Typical lawyer answer. All right, last question, okay? And I know that we do not receive any new questions here in the chat. I'm not sure if this is a technical glitch here in my system or just people are so overwhelmed with the 6,000 round of invitation that they just decided to drop off and disconnect, but whatever. If you send your question but we did not pull it up, please accept our apology. We just don't have your question here in the chat. Okay, the last one is from Kaisi King. Okay, if upon applying, if upon graduating, I have French at CLB 7, can I enter the express entry pool immediately for only the purpose of a French draw and not an occupational draw, or do I still have to wait 6 months? So I think the question is, uh, if you speak French, do you also need to meet the criteria for any other category? Um, the short answer is no. The Francophone category is a category on its own, but you still need to meet the eligibility requirements for one of the programs. Basically, those are federal skilled trades, federal skilled worker, and Canadian experience class. To make it simple, unless you work in trades, you don't even think about trades. Uh, if you have no Canadian work experience, you only have an option applying under federal skilled worker program. And the minimum eligibility criteria for that, the main one, is that you have 1 year of continuous full-time skilled work experience or an equivalent in part-time obtained outside of
In
Canada
one knock.
in one
Yeah.
knock, and it has to be continuous. With Canadian experience class, it does not need to be continuous, but you cannot use your Canadian work experience obtained while you were studying. So if you meet the requirements under one of the programs and you speak French, then perfect. Then you can create a profile typically, right? And again, we know only certain information about your file, and this is not legal advice. This is legal information based on what we know.
And I think maybe we'll almost wrap it up. I think, Igor, there is one question that I just wanted to grab, and that was with respect to studying while you're on an open work permit. And
I don't see it, Alicia.
y-
It just doesn't show up on my end for some reason.
it was very early on, and it
Okay.
was somebody asking about personal support worker courses on an open work permit. So if you maybe search PSW, you might find it. But um, be super, super careful. If you are on a work permit, then it does not allow you to study, right? So a study permit allows you to study, a work permit allows you to work. In some circumstances, if you're a full-time student and you're under the rules for study without a work permit, you might be able to, or work without a work permit under a full-time student, you might be able to do that. However, if you're on a spousal open work permit, you're not allowed to study. And you've got to be super careful that you're not studying without authorization. Personal support worker courses, it really depends. Is it offered through a designated learning institution? But anything that could be considered studies in Canada. So take a look. IRCC has a program page on distance learning. Sometimes you are able to take fully online courses as long as there is no in-person invigilation. So as long as it's 100% online, it's all distance learning, you're not through a DLI, you're just doing courses or on the job training, that is probably going to be okay. If, however, you have any sort of in-person component, you are at a designated learning institution, it's something that you would normally require a study permit for, you've got to get a study permit, because otherwise they can say you're studying without authorization.
And Alicia, this is so frustrating that RSSC says on their website, you can study without a study permit as long as your program is 6 months or less. This is wrong. Like, they have it
It's
wrong on
wrong.
their website, and so many people get in trouble for this. And
You
what's
can
even more
only, yeah,
frustrating is that schools recommend that, oh, this program is less than 6 months. We don't really care if you have a study permit or not. They actually encourage people to enroll in those programs when it would be illegal for them to do it. I have a client who's just like in this situation right now, and I'm like, if you go into the law and case law specifically, where the court analyzed it and said the law says this, you can only study if it's less than 6 months and will be completed within the 6 months period of your initial entry to Canada upon entry. And so if you had a work permit and then you switch to a visitor or vice versa, whatever, um, unless you complete that short course within the first 6 months after you cross the border, then it's an authorized study,
yeah.
and with all sorts of complications that arise from there.
Yep. And we've talked about this a lot because it is super frustrating. And I agree with you, Igor. IRCC should amend their page because there is definite federal court case law that says the legislation is really clear. It says your initial period of entry. So Igor is
Mm-hmm.
100% correct. When was the first date you ever set foot in Canada? And from that date, you could have maybe, if you meet the eligibility criteria under a short-term course of study, be eligible for those first 6 months. But also the program duration can't be longer than 6 months either,
Mm-hmm.
right? So that short-term course of study has to be done in the first 6 months from when you ever first set foot in Canada, and the program duration can't be longer than 6 months. And there's some other wrinkles about it. So be super, super careful because in general, no, you cannot study.
Mm-hmm. Yeah. All right. Because I don't receive any new comments in the chatbot, um, I'm sure there are comments, but we just don't see it on our end. And because we're 40 minutes in overtime and we have only 20 minutes left for our team meeting, we will be saying goodbye to everyone until next Wednesday. It was a pleasure to speak with you, Alicia, to read your wonderful questions and comments. I don't get to do those live Q&As too often right now just because of a change in my personal circumstances, not to be sharing too many details about it, but it happened. Um, and yeah, you guys will see Mark and Alicia next week, next Wednesday. Thank you, everyone, and have a wonderful day.